It is clear from the Speaker's ruling that when the dispute as to which of the two coalitions, Azimio Coalition and Kenya Coalition, was a majority party, he sought to satisfy himself of, among other things, the membership and the status of those coalitions, and to that end he wrote to the Registrar of Political Parties through the Office of the Clerk of the National Assembly seeking for this information. It is also clear from the ruling that the Registrar of Political Parties responded to the clerk's letter before the Speaker rendered his ruling. According to the Honorable Speaker, the Registrar did not provide all the information that he required, but it is clear from his ruling that the Registrar provided information to the effect that Roman 1, there existed Azimio la Umoja coalition party that comprised 26 political parties which include UDM, PAA, MCCP, and MDG political parties. Roman 2, there existed Kenya Kwanza Alliance coalition consisting of 15 political parties. Roman 3, Maendeleo Chap Chap Party Movement, MCCM Pamoja Africa Alliance, PAA, United Democratic Movement UDM, and Movement for Democracy and Growth MDG, had filed constitutional petitions or objections against their membership in the Azimio la Umoja coalition. It is also apparent from the Speaker's ruling that on the 6th October 2022 at 8:30 a.m., the Honorable Speaker also received from the Registrar of Political Parties certified copies of the coalition agreements for the Kenya Kwanza Alliance coalition and the Azimio la Umoja One Kenya coalition party. Armed with this information, together with the election results declared by the IBC, the Speaker could, and indeed did, determine that Azimio coalition had the largest number of members, followed by Kenya Kwanza coalition. But the Speaker was not prepared to declare the Azimio coalition as the majority party for the reasons: Roman 1, the Registrar failed to mention the existence of any post-election agreements, which the Speaker found to be a glaring omission. According to him, there were post-election agreements that had been tabled by the member of Kikuyu constituency during the proceedings. Ostensibly, these post-election coalition agreements had been entered into by UDM, PAA, MCCP, and MDG political parties. The Registrar had shied away from making a determination on the post-election status of the existing coalitions in light of the submissions made by part of the membership of the houses and letters written to me by a number of members relating to the post-election coalitions. 3 members of the National Assembly elected on UDM, PAA, MCCP, MDG party tickets had written to the Speaker dissociating themselves and their parties from the Azimio coalition and associating themselves with the Kenya Kwanza coalition. As a matter of fact, they had declared that they were in a post-election coalition agreement with the Kenya Kwanza Alliance. 4 members of the National Assembly elected on UDM, PAA, MCCP, and MDG party tickets had exercised their right to freedom of association under Article 36 of the Constitution and, quote, migrated to the Kenya Kwanza coalition, to the Kenya Kwanza alliance, both in writing and in action, close of quote. The Speaker held that the parties have, in quote, signed and deposited with the registrar, close of quote, coalition agreements. 5, the UDM, PAA, MCCP, and MDG had raised objections or filed petitions in this honorable court contesting their membership in the Azimio coalition. Now it is worth noting that the Speaker, having been sued in this petition as the third and fourth respondents, apparently in his official capacity and private capacities, respectively, swore and filed a replying affidavit dated 23rd November 2023 in response to the petition. Nowhere in that affidavit has the Speaker alluded to or provided any evidence of the existence of any post-election coalition agreements involving UDM, PAA, MCCP, MDG, and the Kenya Kwanza alliance. There is simply no evidence of any post-election coalition signed and deposited with the registrar of political parties as alleged by the Honorable Speaker or at all. As a matter of fact, none of the rest of the respondents, including Honorable Ichung'wah, who is said to have tabled the post-election coalition agreements in Parliament during the debate on the issue of the majority and the minority party in the House, has exhibited any such agreement. According to Section 9(1) of the Political Parties Act, the Constitution or the rules of every political party shall provide for all the matters specified in the second schedule of this Act. One of the matters specified in the second schedule of this is the requirement that the Constitution or the rules of a political party must provide rules for entering into, particularly Rule 21 of the Schedule 2 to the Act. It has not been demonstrated, at the very least, that any of the parties alleged to have entered into a post-election coalition agreement with Kenya Kwanza took any step in compliance with this particular rule, enter into a coalition agreement with Kenya Kwanza. In the absence of any proof of post-election coalition agreements entered into between UDM, PAA, MCCP, and MDG, and the Kenya Kwanza Alliance, the Speaker cannot be heard to fault the registrar of political parties for not producing them. She could not produce what had not been deposited at the registrar of political parties. If it is true the UDM, PAA, MCCP, and MDG political parties had signed and deposited the agreements with the registrar of political parties, we are entitled to assume that they must have had in their possession copies of these agreements or evidence of the existence, and which they were under an obligation to exhibit in these proceedings. At the very least, the Speaker or Honorable Ichung'wah ought to have exhibited these agreements, which the Speaker singled out as having been presented on the floor of the House during the debates. Without these post-election coalition agreements, the Speaker had no basis to disregard and dismiss the registrar of political parties information on the membership of Azimio Coalition and Kenya Kwanza Coalition. For the same reason, the Speaker had neither the legal nor factual basis of declaring UDM, PAA, MCCP, and MDG as having migrated from the Azimio Coalition and joined the Kenya Coalition Alliance. Again, the fact that there were pending disputes either in this court or before the Political Parties Tribunal on the membership of UDM, PAA, MCCP, and MDG in the Azimio Coalition could not have been a reason for the Speaker to rule that the parties were in Kenya Coalition rather than in Azimio Coalition. Based on the information provided by the registrar of political parties, these parties were members of the Azimio Coalition, notwithstanding the disputes that were pending for determination. It was never suggested that the coalition agreements between the constituent parties were suspended or held in abeyance in the event of a dispute on the membership. Neither was there any suggestion or evidence that either this Honorable Court or the tribunal before which these disputes were pending for determination had stayed or suspended the coalition agreements pending the resolution of these disputes. It follows that by assigning to Kenya Kwanza Coalition, the Kenya Kwanza Alliance, the 14 members of the National Assembly elected under UDM, PAA, MCCP, and MDG party tickets without any justifiable cause or reason, or in the process declaring Kenya Kwanza the majority party in the National Assembly, the Speaker acted arbitrarily and violated Article 108 of the Constitution.
It is hereby declared that the question as to which party or coalition of parties is the majority in the National Assembly in the 13th Parliament was determined by the sovereign will of the Kenyan voters during the 9th August 2022 general elections. 2. It is hereby declared that the Honorable Speaker's ruling or determination contained in his communication from the Chair made on 6th October 2022 on the majority and minority in the National Assembly violated Article 108 of the Constitution, and therefore it is null and void. 3. It is hereby declared that the Honorable Speaker's ruling or determination from the Chair on 6th October 2022 with respect to leadership of the National Assembly on account of his determination of the majority party and minority party in the National Assembly is contrary to and violated Article 108 of the Constitution. To that extent, it is null and void. 3. An order of certiorari is hereby issued quashing the Honorable Speaker's ruling or determination contained in his communication from the Chair made on 6th October 2022 on the majority and minority party in the National Assembly. 4. Subject to the foregoing orders, the rest of the prayers in the petition are declined. Parties will bear their respective costs. Those are our orders.